Howdy, and welcome to the third and final video of Introduction to the Legal Terminology and Concepts. What I'm going to do in this video is walk you through Chapter 1 and some concepts that you should know to guide you in your reading. As soon as the slide progresses, I have no idea why it does this. Come on. Okay, so I'm going to call this Learning Objective Summary. Yeah, it's not in the right format. Bear with me here, but I'm going to just walk you through. For instance, on page 1, it talks about reasonable steps, and this is a legal term, reasonable standard. When you see the word reasonable, it means the reasonable personal standard. What would a reasonable person do in this? Okay? So when it says, second paragraph, in recent years, the FTC has brought dozens of enforcement actions against companies that it believes have failed to take reasonable steps to secure the personal data of their customers, reasonable to that industry. Okay, what is reasonable to that industry? Second thing, we're going to talk about this more in detail next week. This is just to help you understand this. Another good term is offends public policy. So let me give you a scenario. There's a contract that I have you under a non-compete, and you signed it. You're an educated person. There's consideration, so it's a valid contract. There's no reason to say you were under duress. You signed the contract of your own free will. You had the highest mental capacity when you signed it. But the courts can still nullify that contract if it offends public policy. Our laws are in place to keep order in society. And so sometimes you will see, for instance, there's a case where in that non-compete, then public policy is to encourage the economy and job growth. And if I try to hold you to non-compete for 10 years or something excessive, even though the court would say, yeah, this was a valid contract, but guess what? We're going to invalidate it because it offends public policy. So you'll see this term come up many times. Now, when you read this, I want you to focus on two cases, the Wyndham case, and I want you to, and usually I don't care about case names. I'm not teaching you to be lawyers, but I want you to focus on that. I want you to start looking at all the errors and you begin to see a pattern. Credit card data was in clear text, simple passwords, failure to use firewalls, failure to do this or that. The Wyndham case stands out because it was the first time the FTC said, the court said the FTC has the right to bring these actions. And look what circuit it is in. It is in the Third Circuit. Go back to our map. That includes Delaware because that's probably where Wyndham is incorporated. So this was a landmark case because, again, it may not be binding in other circuits, but it is very persuasive. Okay? There's some other words here. Consent order. A consent order is where the FTC orders a company to do something. A consent agreement is where the company basically negotiates with the government, signs the agreement, and it is basically a contract with the United States to fulfill that. So you can actually, this happened with Facebook. They did something, it was not illegal, but they signed a consent agreement in 2010 or 2011 with the FTC, and then under Cambridge Analytica, you could make the case that they violated that. They violated their contract that they had come with the FTC to better protect privacy. At $40,000 violation, the fines could be $1 trillion. Okay, let's see, what else do we want to see? We want to look at the significance of precedents in the cigarette rule. I didn't put a page number on that. But again, wait a minute, cigarette, this was about liability. This wasn't about cybersecurity. Again, remember that we look at the law as process and the precedent, and we look at the rule of law. Not the fact it was about cigarettes or anything else, the rule of law. So this is where the Supreme Court came up with the three-pronged test and then codified that into law of what could be for standing, okay? And in cybersecurity cases, the FTC looks for actual harm. But again, we have a split in the circuits right now. Is it harmful if your identity was really stolen, or is the threat of your identity to be stolen significant to be harm? It's not a question that there has to be harm. There has to be harm. But it's a question of what constitutes harm. So, and arguably, if your identity is stolen and you have financial consequences, then that's harm. But now some of the circuits are saying, and some of the circuits are saying no to this, that just the mere threat of having your identity stolen constitutes harm. So this is the kind of thing I want you to look for as you read chapter 1. Let's see what else. The significance of the Wyndham case, the process of agreeing to a consent order, all of this, I'm putting this out there so as you go through the several poor cybersecurity acts, you begin to see this. Now, as you walk through this, and this says this in the syllabus, it's going to have a lot of cases. I want you to read the cases, but I want you to hone in on the key lessons. And by the way, my book is all marked up. I'm old school. I mark up my book. So when you look at something, then go to the key lessons and you begin to see the pattern of where you begin to see the commonality as the law is evolving. Eli Lilly, again, read through the case. I don't care about the details, but then look at the key lessons. It's several cases here. The big case again is LabMD, which we will talk about in class because this book is actually outdated on the changes in LabMD. But you begin to see where the court's grappling with this with the FTC. And to me, it's very interesting that the FTC, that unreasonable practices section, is over 100 years old. So again, this is where we've taken existing law and tried to apply it in this case. Okay, let's see what else. The key takeaways, it's what's going to constitute unfair or deceptive data. It's going to be the significant risk of injury. Is it sufficient to meet the likely to cause requirements? There, again, the FTC does not have a formal definition of sensitive information, so how are they telling us to protect it? And we haven't talked about this in our online course, so let me take a few minutes. We have 3 branches in American government. The statutory law is by the legislative branch, Congress, House of Representatives, Senate. At the federal level, signed by the president. On the state level, you have a similar bicameral, meaning 2 houses. Bicameral, we typically have that. We have a state representative and state senator in Texas, and then the laws go and can be signed into law or vetoed by our governor. And then there's always an override. The Congress of the United States can override the president's veto. The needed majority is much higher. The same thing. So we have these 3 branches, and we tend to think of the laws coming out of the legislative. But in fact, our other 2 branches, the executive, headed by the president, and the courts. If we talk about the executive, all of these agencies we're talking about, FTC, all these federal agencies come under the executive branch. That's why the president appoints the heads of these agencies. They make law. They make law because they, like the FTC, will have regulations, or they take law passed by Congress in the USC, and then they take that into administrative law. So the executive agency has laws too. And in fact, some of these regulations can also be criminal causes of action. Your third prong of the United States government are your courts. And that's where our common law come in, when the judges make laws. So there's 3 branches, the legislative, the executive, and the judicial. The legislative, 2 houses, bicameral, pass laws. Our Congress at the federal level, our Texas legislatures meeting now. Then we have our executive branch with all of our executive agencies putting out regulations. It's a regulatory agency. And lastly, we have our judicial. So I hope that's good. Next lecture, next week, we will start in chapter 1 in detail. Thank you for paying attention.